What was your initial reaction when you heard of the Court of Appeals acquittal and discharge of Sedina? And now that you've read the judgment, how do you feel?
With the greatest of respect and humility, I think in many places the Court of Appeal was wrong, and I'll demonstrate that to you. I'd read the High Court judgment. I listened to many discussions, including my brother. Over the weekend, I was in Kumasi. I listened to him. The High Court judge, the Court of Appeal judges at many places were wrong. Mm-hmm. And I'll demonstrate that very respectfully with ease. Mm-hmm. The prosecution had discharged their burden. And the Court of Appeal judge focused too much on things the prosecution did not do, instead of evaluating the evidence before them and giving us the legal effect of what was before them.
Okay. I see.
Let me repeat it. They focused on things in their opinion the prosecution should have done, instead of evaluating what was before them and giving us their legal position or their legal consequence as far as the law of evidence was concerned. You see, an appeal is by way of rehearing. So you rehear the matter without the drama attendant with the High Court trial.
Okay.
At that stage, you have the benefit of the record from the High Court. And so you have to look at the evidence and look at the law, the elements of the criminal charge, and determine whether there is enough evidence on record based on the rules of evidence that satisfies the offense.
Okay.
And so, in my view, that was what they ought to have done. It is not what the Attorney General, right?
The prosecutors.
It's not what the prosecutors failed to do at that point. Tell us the effect necessarily. Let's take Obatampa.
The company that supposedly made those payments. And I'm jumping the summary because this is a developing story. So a lot of my viewers would have known the basic facts.
Sure.
So proceed.
So the prosecution had laid a charge of stealing or had preferred a charge of stealing against Obatampa. There was no dispute that money had been transferred to Obatampa. There was no dispute before the court. What was in the contention was whether or not the money had gone to Sedina. And if the money had gone to Sedina, right, whether or not Sedina had the intention of appropriating the money or keeping it permanently for the purposes of your listeners, that she wanted to keep the money and make it hers. That was the contention. Indeed, in view of the disputed fact of whether or not the money had been returned to Sedina, right? If the case that the money had not been returned to Sedina is established, you don't need to go on to establish whether or not it's an intention to appropriate the money. But if you establish that indeed the money had been returned to her, then you have to go on to establish that it's an intention to keep the money permanently. Now, how did the prosecution move on to prove this? They called the witness from Obatampa, who comes to say, we delivered the money to her. Not just that, he gives you the location where the money was delivered to her. From the two judgments, the High Court judgment and the Court of Appeal judgment, there is no evidence of Sedina's lawyer during cross-examination challenging Obatampa.
On which fact? On
the fact of whether or not, on the fact of his claim that he returned the money to Sedina at Bachuda Tuta. What is the effect of this in law? The Court of Appeal did not discuss. It is very vital The effect of this is an admissibility in law. When a crucial evidence is not challenged, it amounts to an admission. And so in going into the appeal, the fact which had been admitted was that the money was returned to Sedina. Unless you challenge this, without a challenge, that is the effect in law.
I see. So that's your first
That's
gap.
my first gap.
Because of time, I want you to be like bulleted.
My second gap is that Exhibit A was tendered as evidence of the return of the funds by Obatampa's representative.
Okay.
Right? That Exhibit A, the Court of Appeal sought to assail it by saying that on the strength of Sedina's statement to the police, it had been impugned. In other words, she has raised doubt about the Exhibit A. And therefore, the court should have done a better assessment of it. I think that the court misdirected itself on the position of the law. And that misdirection, which is an inconsistency, look, if you go through the judgment, that misdirection indeed becomes obvious. And I'll demonstrate to you. You see, Sedina had not gone into the witness box to testify. So the statement she gave to the police had not been tested. And you cannot use an unsworn and untested evidence to assail a tested evidence. How do you test evidence? You test evidence through cross-examination. That is when you test the veracity of the evidence. Sedina had not gone into the witness box, and so she had not been cross-examined. Her statement to the police had also not been cross-examined. How do you use an unsworn evidence, right, to impugn a sworn evidence? And he himself, the Court of Appeal judges themselves, right, contradicts themselves in this judgment. And I'll show you. Let's go.
So this is still on point 2.
This is
point 2B.
Point 2. This is point 2B.
Because I'm trying to get the logic of the specific things.
I'm coming to tell you.
So the Obatampa issue, no challenge.
So when you come to
and the exhibit tendered in, not cross-examined.
So when they were evaluating, when the court was evaluating,
this is the High Court or the
this is the Court of Appeal's decision.
Okay.
When the Court of Appeal was evaluating the charge of sensitization, right? One of the issues at hand was that the officers of the regional officers of MASLOC had given Yoko a written statement, but they were not called to testify.
Okay.
And for that reason, the court deemed their written statement to be a hearsay and could not be relied upon.
Fair enough.
It is the same written statement which you relied on to impugn.
They talk about an Yoko investigation.
Yes.
Which they called it.
Yes, but that is the written statement to the police. That is the statement I was giving to Yoko. Sedina's statement was to the Yoko, and that is the police.
But are you not forgetting that one person is alleging and one person is defending? So that if I'm a judge, and based on my non-law understanding of this, if somebody is saying that you are a thief and he presents evidence that you are a thief, he must prove beyond reasonable doubt that you are a thief. As against me saying I'm not a thief, I don't have to prove beyond reasonable doubt I'm not a thief, right? So I think that the understanding is that the Court of Appeal said the burden on the person alleging is stronger than the person defending.
It doesn't change anything. It doesn't change anything. What it means is that you produce evidence to prove your claim.
Beyond reasonable doubt.
Beyond reasonable doubt.
That this person has committed the offense.
Good. And what is the evidence provided in this matter? The evidence provided in this matter is that Obatampa people say they gave money to Sedina, 500,000, which was a refund or a return of money they had given.
Did they show evidence of giving the money beyond the assertion?
So you have to distinguish this. I think that we confuse something. Sometimes we make it seem as though oral evidence is not evidence. Oral evidence is evidence. It is when it is challenged that you need to provide more evidence to support or corroborate your position. Now, Obatampa, who had been given the money, came to testify that we have returned the money to Sedina.
All right.
That is evidence.
Did they provide anything to back
You
that
don't
claim?
need that until it becomes necessary. And this is where I say there is the misconception.
Fair enough.
Evidence is either oral testimony or material evidence, which is relevant to the issue which is being resolved by the court. And so in proof of your assertion or your case, you may call oral evidence or you may produce material
So
evidence.
the point is very clear. So you've done 10 minutes, by the way. So I'm keeping time. So can you make your final comment on the
So my point is that
Court of Appeal thing? Then
the prosecution proved this case by calling the very people who had returned the money to Sedina.
All right.
The prosecution proved this case by providing evidence, which is Exhibit A,
Okay.
right? The judge misdirected itself, the Court of Appeal judges misdirected themselves when they used an unsworn testimony to impugn a sworn and tested evidence. An unsworn and untested evidence cannot be relied upon. And the Court of Appeal itself stated that in their, let me show
But are
you.
you suggesting that everybody who's defending themselves have to necessarily testify in a case against them?
Let me explain to you. You don't. But where it becomes necessary, you have to. And this is another misconception. In any matter, you have no obligation to defend yourself in court.
You can even decide to keep quiet.
You can even decide to keep quiet. But when the burden shifts, if you don't speak, it will be ruled against you.
So how do you tell me that the burden shifted?
When you produce sufficient evidence, and in this particular instance, it is my submission that sufficient evidence had been produced, and the court rather focused on what in their opinion ought to have been done, instead of evaluating what was before
So
it.
essentially, you agree with the High Court, you disagree with the Court of Appeal?
Yes. The court rather focused on what, in their opinion, should have been done by the prosecution.
So you're giving me 3 solid points. Let me take Alaji's view. You said somewhere that this...
If I may point, please, Allah,
Okay.
let me point you to
I'm doing time.
I appreciate. You see, this thing, there's a lot of misconception going around.
Okay.
And because people are reading the judgment with all humility like a storybook.
Okay.
And so because of how well structured the judgment is, you can easily be swayed. If you look at it very critically, evaluate it in accordance with the rules of evidence, you appreciate what we are saying.
Some people even think that rather the atmosphere had been poisoned by the fact that they were baying for blood, and therefore the Court of Appeal's judgment rather was met with a lot of anger because people who haven't even read the original judgment and the Court of Appeal's judgment were feeling upset.
No, because people, you see, the truth of the matter is that people are aware of the manner in which this whole thing, the chronology, the sequence, people are aware. How does a criminal appeal ordinarily, if it wasn't for Sedina, how would it be done in less than 6 months? How do you go ahead to
the
hear,
speed as well.
The speed. Okay. How do you even go ahead to hear a matter when the convict is not in the jurisdiction? Hear it. You see, the hearing is different from the judgment.
So you've spoken about the speed as well, and also spoken about the not being. Okay, so Baffour, you've made 5 points.
Let me quickly refer you. I beg you.
Okay.
I'm begging you. You see, let's go to the sensitization bit where the judge made.
You've made a Batampa testimony point. You've made Exhibit A point. You've made the standard of 2 testimonies not having been sworn. You've made the unusual speed point, and you've just added a 5th point about not being in the jurisdiction. That's 5 points.
I want to add a legal position to it.
Okay.
From the same judgment.
Good.
From the same judgment, paragraph 86. By the operation of section 60 subsection 1 of NRCD 323, a witness must speak only to matters within their personal knowledge. section defines hearsay evidence other than statement. Therefore, statement made outside the courtroom cannot be admitted as proof of their assertions. Witness statements given by an accused person or any other potential witness to the police is a statement made outside of the courtroom. It's made outside of the courtroom. It's not made inside the courtroom. Mm-hmm. When you go into the witness box, right, and you take an oath, you testify.
Yes, we understand this.
Good. Now, the statement by Sedina, right? The statement by Sedina to the police, which the judge relied on, had not been tested, was never tested. Because
you've made, and you're saying that, of course, neither was the Yoko statement also tested. So we understand.
Once you exclude, or
you should exclude. Well, fair enough. Agyei, thank you for your time. You said somewhere that this judgment was seminal in relation to the role of prosecutors in criminal trials. That's a very, because there have been some big cases. So there have been Atufosin, there have been a few others in terms of Court of Appeals. Why is this seminal?
It's seminal because it goes to the duty on the prosecutor in prosecuting a case. I mean, let me put it in another way. The law imposes a duty on prosecutors, whose duty must be discharged at all times, whether the accused person is within jurisdiction, is outside jurisdiction, or simply refuses to talk.
Okay.
And that is improving the guilt of an accused person. The burden of proof is on the prosecution.
Okay.
The standard of proof is also on the prosecution, unless the offense is a strict liability offense, or in some cases, licensing offenses. Now, in licensing offenses, you can frame the charge in the negative. You are operating without a license. Now, because it's a licensing matter, licensing offense, and the ability to determine whether or not the accused person is operating within the law and has a license, he's given a license, so he produces the license. He discharges the burden that he's not, so that's where it shifts. Now, so in this case, when you read the judgment, and with the greatest respect to my colleague, lawyer, and member of parliament, I know that when the decision came, everybody, including myself, were confused. In fact, we were very emotional because we just calculated the time that a certain number was extradited from the United States to Ghana. And she had not even spent up to 3 months in jail, and she was walking away. But as a lawyer, I was now sitting with very important, big people, educated people, and everybody was talking. They asked my opinion. I said, I can't give an opinion then.
You hadn't read the judgment.
I said, I'm also surprised. But this level of surprise can only be answered if you read the judgment.
Of course.
Because as a lawyer, I know, and all of us know, that when an appeal is filed, it goes through processes. Okay? So it is not the case that you file an appeal and hear it in 6 months. It's not the case. Baffour-Awuah, that's not the case. The appeal itself was filed on the 9th of May, 2024. After the appeal had been filed, records were settled. When the records are settled, and the registrar of a court will not settle records if the hearing notice for the settlement of record is not served. But if the hearing notice is served and there's proof of service and one party elects not to be president, the registrar will go ahead and settle the records. The records were transmitted. And so there are processes. And when you calculate the processes, that are involved in an appeal, you'll be left in no doubt that this appeal went through all those processes. Now, I want us to look at what the Court of Appeal is saying. It's saying that some of the charges were defective.
They said 34 were irredeemably
defective.
That's a very serious word. It says that they can't be saved.
And the court relied on the Ernest Thompson case.
Yeah.
And when the charges were defective, the court ruled that they were defective. So the Attorney General had to go back and redraft the charges. Okay? And Article 19 of the Constitution, which is part of the fundamental rights provisions, requires that you inform the accused person of the offense that he's been charged with, so that he or she has been charged with, so that person can prepare the defense. You can ambush the accused person in court and keep all the evidence, and then confront the accused person in court with evidence that he or she does not know about.
Okay.
But what is really disturbing in this case is that in two instances there were exculpatory evidence for Sedina. One is the Cantonment Fire disaster. The investigator produced a report and indicated in the report that his investigations had established that the money had been paid out. Baffour-Awuah and Co. did that.
Let me see.
No, please.
I'm not the Baffour-Awuah.
Yes.
I'm not saying that you.
Yes.
But you're not an accountant.
Yes.
Agyei,
but let me clear it.
Yes.
It's Patrick.
Yes. People have been saying that
You are the guy.
I'm the guy. I'm not.
Yes.
I don't. If he's here,
So it's an accounting firm.
It's an accounting firm.
Yes. But I've never.
It's not even
met
your
him.
relative.
No.
So you are
it's
Nana
not-
Agyei Baffour-Awuah.
Baffour-Awuah, yes.
And that's Baffour-Awuah and
It's
associates.
possible we may be related, but I've never met him
It's
before.
important you make
But
that point.
Baffour-Awuah himself is a grown up
person.
man. He's not a
Yeah,
young man.
but-
So
but
maybe
people don't
maybe
know.
people doing it
People
mischievously.
don't
Proceed.
know.
Had done an audit of the activities of Sedina at MASLOC and had cleared the payment.
Okay.
And that was known to the prosecution at the time that they were prosecuted. It was known. Thirdly, the successor of Sedina Tamakloe gave evidence in court and said that they were no longer pursuing the Cantonment Market Fire case.
Okay.
That it was no longer relevant. These were the words Stephen Amwa used in court. But prosecution went ahead, charged her of the offense, and then the court convicted her on the offense in which exculpatory evidence had been provided. So that is one. You see that the prosecution in the Sedinam case at the High Court appeared to be more interested in conviction rather than justice. No, the second thing that baffled my mind was the car issue, the 61 million. You have Sedina Tamakloe is said to have committed the government of Ghana to a system 1 million deal, and that the cars had been delivered, and that the deal was tainted with fraud, illegality, because she had no authority so to do. The state decided to go ahead with the contract.
Okay.
Whoever gave Stephen Amwa the authority to renegotiate the contract, we are not told.
He's the CEO of MASLOC who took over after Sedina.
How much he renegotiated the contract, we don't know. How much the state paid for the renegotiated contracts, we don't know. But most importantly, we knew that, we all know now that Sedina paid nothing.
She was not she wasn't in office when the payments was made.
She didn't pay anything to
Although the contract was signed in her time.
Yes, but she didn't pay.
But had you renegotiated?
Renegotiated.
Okay,
So when you renegotiate the contract,
you are saying you can't be convicted of a payment
that was made. A contract that was renegotiated.
Yeah.
So when you renegotiate a contract, to all intents and purposes, a new contract has come into being, and then you convict the outgoing CEO for committing Ghana to a payment.
Unless maybe the new CEO thought that her original contract was so badly signed and that locked us to the extent that he could only beat down the cost, but couldn't.
No, if the original contract was so bad, was so tainted, the option was there: repudiate liability. Simple. And that becomes your defense.
So if you've made two big points.
Third one.
Okay.
Sedina was paid ex gratia, not by herself, but her finance director, who was a prosecution witness, who came to court to testify that he paid Sedina and the deputy the ex gratia.
Okay.
And the ex gratia was calculated based on documents. That is her appointment and terms and conditions of service and other documents which were relevant for the calculation of the of Sedina and her deputy's ex gratia. And said affirmatively, conclusively, that he authorized the payments. Sedina was convicted on account of paying herself ex gratia when she had no lawful authority.
Okay. So what I've seen is you've pointed three holes in the original High Court judge's decision. And he's pointed some holes in the Court of Appeals decision. So I want to.
No, I'm just saying. I'm not. I'm come out in the Court of Appeal.
I know. I'm summarizing what I've heard so far.
No,
unless you have one more point to add.
He's not holding the High Court judgment.
I have the High Court judgment here.
Yeah, but he didn't refer to the High Court judgment.
Oh, because
so that's what I'm saying. So he's interested in the one he doesn't agree with.
Judgment
and you are interested in the one you don't agree with. So it's fine. So I wanted to take a breather. When I come back, I have a referee. So I asked him to just tell me what he thinks of the two angles to the discussion. So give me a minute. This is the point of view. Tonight we're doing two things. We're looking at the Court of Appeals discharge and acquittal of Sedina Tamakloe, former CEO of MASLOC. And then we'll also talk about the government's position paper on the Constitution review. Stay with us.